Monday, November 9th, 2020. It's approximately 7 o'clock, and I'll call this meeting of the Board of Adjustment to order. Before we go any further, I'd like us all to take a moment of silence in remembrance of our late member, Mike Wellner. He not only served on the Board of Adjustment, he was a servant of the city of Apache Junction for many years. So I'd like to take a moment and all share our thoughts and think about Mike. Thank you. Would you please rise and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. As we take roll call, I would like to welcome all our new members. And Rudy, would you please take that roll call?
Yes, sir. Board Member Busin.
Present.
Board Member Durbala.
Present.
Board Member Knox.
Present.
Board Member O'Hara.
Present.
Board Member Osaki.
Here.
Chairman Shanebeck.
Here.
Board Member Waldy.
Here.
7 present. We have a quorum, Mr. Chairman.
Thank you. At this time, I would entertain a motion to approve the agenda.
Make a motion, we approve the agenda.
Do I have a sec-
Second.
Motion's been made and seconded to approve the agenda. Could we take a roll call, please?
Board Member Waldy.
Yes.
Board Member Busin.
Yes.
Board Member Durbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
Chairman Shanebeck.
Yes.
So moved, Mr. Chairman.
Thank you. At this time, I'd entertain a motion to approve the minutes of October 7th, 2019.
Chairman, I'll make a motion that we approve the minutes for October the 7th, 2019.
Thank you.
Second.
Thank you. I have a motion and a second. Roll call, please.
Chairman Shanebeck.
Yes.
Board Member Waldy.
Yes.
Board Member Busin.
Yes.
Board Member Durbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
So moved, Mr. Chairman.
Thank you. Our next order of business is to elect the chairperson and vice chairperson. This process is somewhat involved and needs to be followed in certain steps. The first step is I'm going to call for a motion to open nominations.
Chairman, open the nominations.
I second the motion.
Thank you. I need a roll call on that, please, Rudy. It's been moved and seconded that we open nominations for the chairperson. I need a roll call for that.
Board Member Osaki.
Yes.
Chairman Shanebeck.
Yes?
Board Member Waldy.
Yes.
Board Member Busin.
Yes.
Board Member Durbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
So moved, Mr. Chairman.
Thank you. At this time, I would entertain nominations for chairperson. Before I do that, I would like people to know that I would not be interested in serving another term. It is my personal belief that this position needs to be shared among members of this committee, and it makes for a stronger committee to have different people in this chair. So, with that being said, yes,
Like to nominate Mr. Walkie,
okay.
since he has been the vice chair for you.
Yes. I have a nomination for Walt.
Second.
Yes. All right. At this point, I call for any other nominations? I call for another nomination 3 times here. The second time, I call for any other nominations? Are there any other nominations? At this point, I ask for a motion to close nominations for chairperson.
Mr. Chairman, close the nominations for chairperson.
I need a second for that.
Second.
Thank you. Rudy, a roll call, please, on closing the nominations for chairperson.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
Chairman Shanebeck.
Yes.
Board Member Waldy.
Yes.
Board Member Busin.
Yes.
Board Member Durbala.
Yes.
Nominations are closed, Mr. Chairman.
Thank you. At this point, I would call for a nomination to approve the first person nominated for chairperson. If that majority prevails, no more names will be voted on. If no majority, repeat roll call with the second person nominated until that chairperson is selected. So I'm now looking for a motion.
Motion to accept the position for Mr. Walken? Is that the motion you're looking for?
I'm looking for a motion that Walker Waldy be approved for chairperson.
Then I make a motion that Walter be approved for chairperson.
I need,
Second.
motion's been made and seconded for Walker Waldy to be approved for chairperson. A roll call vote, please.
Board Member Busine.
Yes.
Board Member Derbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara. Was that a yes?
Yes.
I'm sorry. Board Member Osaki.
Yes.
Chairman Shanebeck.
Yes.
Board Member Waldy.
Yes.
Congratulations, Board Member Waldy, you're the new chair.
Ooh, let's see. Oh, sorry. Okay, so I call for a motion to open the nominations for vice chairperson.
I so move.
I call for a second.
Second.
Okay, can I get a roll call?
Board Member, Chairman Waldy.
Yes.
Board Member Busine.
Yes.
Board Member Derbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
Board Member Shanebeck.
Yes.
That's a unanimous decision.
Okay, so then I call for nominations for vice chair person.
You have to ask 3 times.
I would nominate Joe Devaldi.
Derbala. I'll accept.
Second.
Well, you don't second. I'm sorry.
Was it say- does
Sorry to
it-
interrupt.
I'm sorry.
Yeah, so you call 3 more times. You
Okay,
ask.
so I call for nominations for vice chairperson. And I call for nominations of vice chairperson.
One more time.
And I call for nominations of vice chairperson.
That's it.
Mr. Chairman, I move that we close the nominations for vice chairperson.
Second.
Okay, so wait.
We need to do that?
We'll take a vote,
Yeah.
Mr. Chairman.
Sure.
Board Member Osaki. Board Member Shanebeck.
Yes.
Chairman Waldy.
Yes.
Board Member Busine.
Yes.
Board Member Derbala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
So moved, Mr. Chairman.
Okay, so I move that nominations for chairperson be closed.
Done. We did that.
Oh, we did that. Second, sorry, first time. Okay, so I move to approve the first person nominated for vice chairperson. If majority prevails, no more names are voted on. If no majority, repeat roll call with second nominated and continue until vice chairperson is selected.
So you need a motion
So
for
yeah.
someone needs to make a
Call for a
motion
motion, yeah.
on who they want as vice.
I move that Joe
Derbala.
Devala be our vice chair.
Second.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
Board Member Shanebeck.
Yes.
Chairman Waldy.
Yes.
Board Member Busine.
Yes.
Board Member Derbala.
Yes.
Board Member Knox.
Yes.
Congratulations, Board Member Derbala. You are now our vice chair.
Thank you.
Joe.
Mr. Chair,
Yes.
on the next item, it's 20-579. I'd ask that these be put after the public hearing, because I think the public hearing is going to be a lot shorter than my 3-hour presentation.
I'm pretty sure they want to hear it. They,
don't know if they
they
want
love hearing about the board ethics, right? No? All right.
You shortened it?
Do I need to make a motion to move that?
No,
or we
you do
just go-
not.
Okay.
It's just
So
an administrative
we're
item.
going to move to item number 7, public hearings. I'm sorry, I made all these notes on my paper and then I left it at work and lost my keys, so
It's,
I'm a little,
it's number 6 for public hearings.
Let me give you my set.
number 7.
Public hearing is number 6.
7 on ours.
We're seeing 7.
Oh, not on mine. That's bizarre. Number 7's old business. Isn't that strange? If something happened here, maybe that's what you should have done with my item too. Wow.
Okay, so public hearing number 7, the presentation and discussion, public hearing and consideration of case BA-1-20, a request by Joe and Sue Rutherford for variance pursuant of the City of Apache Junction zoning ordinance, section 1-16-4, requesting to build a guest house in front of the yard area for the property located at 2179 East Superstition Boulevard.
Hello,
Hello.
I'm Morgan. Oh, no.
Yeah, it's on.
Oh, can everyone hear me okay?
Yes, we can now.
I'm short. Okay, thank you. So, my name is Morgan Henn. I'm the new planning intern for the City of Apache Junction. This is case VA 1-20
Can you get
for
closer
the
to the
Rutherfords.
microphone?
Sorry. So a little bit of background. The property was developed with a manufactured home back in 1997 by a previous owner, and the Rutherfords purchased the property with the home in 2012. The property is encumbered by a FEMA flood zone, AE and AE floodway. There are federally patented easements along the north and east sides, and the property is zoned RSGR, which does allow for guest homes. So here's the vicinity map. You can see that the properties in the area are all low-density residential. There's an aerial map, so you can see that the home is located to the southeast of the property. Again, just zoning, all residential. So here are the federally patented easements. You can see along the north, east, and south. Here's the images of the floodway. So you can see the entire property is in the floodway and in the zone AE. So they are requesting to build a guest house in the front yard area of the property versus the side or rear due to the property constraints of being located in a floodway and having the federally patented easements along the sides. So the appropriate board for this type of request is Board of Adjustment. Here's the site plan given by Rutherford. So you can see the home in the southeast and the guest home in the front yard area. And you can see that there's really not much room anywhere else. So for the first criteria to be granted an appeal for a variance is that there are special circumstances like physical constraints, or if the zoning ordinance prevents the property from enjoying certain privileges that other properties in the area can enjoy. And one could argue that there are special circumstances applicable to this property because it is entirely in a floodway and the property is bordered by the FPEs. The second criteria is that they are not self-imposed by the owner. And like I previously stated, the Rutherfords purchased this property with the home already on it. So planning staff recommends in favor of this request of the Board of Adjustment for the variance to allow the Rutherfords to build a guest house in the front yard area of their property. Our recommended conditions are that all future construction and property continue to properly permitted and be in compliance with normal setback regulations and flood zone requirements. And the second, that property owners shall pay all applicable building permit and development fees at the time of permit issuance. So finding of fact, there are special circumstances applicable to this application. Again, it is in a flood zone and it is lined with FPEs, which limits the amount of area that can be built on. And then the zoning ordinance does cause like unnecessary hardship and limits the privileges because they are not able to build in the other areas. And this variance is a reasonable request, and it's only affecting the front yard area. Any questions?
Just one. Mr. Chairman, just one.
Yeah.
The house shows is 44 wide. I just was curious as to how deep it was. It shows 44 across the front, but there is no other dimension there. Yeah.
The guest house?
Uh-huh. Unless I missed it, but I don't see it. 18?
18.
Thank you. Just curious, not a big deal. I just wondered.
Mr. Chairman, I
Any
have a
other
question.
questions? Yes.
Is this going to be a manufactured home, or is this going to be an actual stick-built home?
Mr. Chair, I'm sorry to interrupt.
Yeah.
And I'm sure the public doesn't know this, but he will get a chance to speak if you could just advise on the rules on that. Because after Morgan sits down, then you will call up the applicant.
Okay.
Okay.
That's
So
how
if we
that
have any
works.
questions for the
The applicant.
Mr. Rutherford, yeah, then we can wait to ask him when he gets up here.
Mr. Chairman,
Yes.
generally speaking, the city's guest house regulations require a guest house to be of conventional construction. Even if the main residence is a manufactured home, a guest house must be of conventional construction.
Okay. Does anyone have any questions for, sorry, what was your name again?
Morgan.
Morgan. Does anyone have any more questions for Morgan?
No.
No.
Okay, Morgan. Thank you.
Thank you.
Okay, at this time, if we can have Mr., was it Rutherford? Sorry. Ruthart. That was close. Mr. Ruthart, if you'd.
Not that I'm not nervous. I don't do these sorts of things, but I'll try to answer your question.
Okay. Anyone have any questions for Mr. Ruthart?
Mr. Chair, I would.
Yes.
I went by your property today, and I am impressed with what you folks have done there. It's, you've made quite an improvement in the neighborhood. I'm sorry for the folks that live to the east of you. That's an eyesore for the work you've done. Does look like you're going to have to wiggle your driveway a little bit around where that home will go. But basically, you've done a very nice job on that property, and
Thank you.
it stands in your favor, I guess, for our decision tonight. But it is remarkable. But I have heard that is going to be a mobile home rather than a stick-built house.
It's a stick-built home, yes.
Oh, it is a stick-built
Yes.
home. Okay.
uh-huh.
Okay. I don't have any more questions.
Any more questions? Yes.
I just want to make a comment. I also drove by, but I drove by Saturday, and he is right. Your property is very lovely, and I was thinking the same thing. You're going to have to change your driveway around in order to accommodate that house, but that may not be a fact.
We see it as not a problem. The driveway will still be the 35 feet before the house begins, so there won't be any problem with what we drive through now. So there won't be a problem with driving in and out of the property.
But he is right. That really does look nice on the rest of the house.
Thank you.
I want you to be complimented on that as well.
Thank you.
Other questions?
I do have one question.
Yes.
You've been there since 2012. Have you noticed any substantial flooding?
The one last year was a substantial flood. And the wash that we have there handles it pretty good, except that when it's real bad like that and it comes up over the highway, then it has come down our driveway. And the area where we are at, our building, of course, everybody got water last year. But normally we don't have a bunch of water in that area at all. But we do have sometimes coming down the driveway when the culvert overflows onto the road, then it'll seep down around if it gets too plugged up there.
So would this dwelling change that flow?
No. No, because it would be off from that driveway, so the driveway would be, it's 35 feet or so of driveway before we start the house. So there would be no problem with water.
Any other questions? Yes, Mark.
I noticed that, I guess all the neighbors within 300 feet were notified that you were going to do this. Just curious, have you actually talked to any of your immediate neighbors about this project?
Well, we have neighbors across the wash from us, and they don't seem to have any problem. The people that are the closest to us, which we share a fence, we happen to know them. They come for the winter, and they have no problem with it. So
Excellent.
when we've talked to them, they think it looks nice. Of course, we get lots of compliments on our property. We're very proud people to make things look better. And I know that the house we put in will look nice, just like the rest.
Sounds good. Thank you.
Any other questions?
Mr. Chair,
Yes.
I move that case BA 1-20, a request,
I have to interrupt you, and I'm sorry again. You have to have a public hearing.
oh, that's right.
I don't know if there's members of the public here, but you need to announce that, Mr. Chair.
Okay, so at this time, we're going to call to the public. If there's any that'd like to come forward and make any statements.
And there isn't any, so
There
I'm
isn't any?
sorry, but we didn't know, but on the record, you have to have a
Yeah.
public hearing.
Yep.
Okay.
Sorry, yes.
All right, so we're looking for a motion.
Mr. Chair,
Yes.
I move that case BA-1-20, a request by Joe and Sue Rutherford for the Board of Adjustment and Appeals to grant a variance pursuant to the City of Apache Junction zoning ordinance, Section 1-16-4, requesting to build a guest house in the front yard for the property addressed as 2179 East Superstition Boulevard, parcel number 103-03-004D, be approved, subject to the following conditions: that all future construction on the property continue to be properly permitted and be in compliance with normal setback regulations and flood zone requirements. 2, property owner shall pay all applicable building permit and development fees of permit issuance.
Call for a second.
I'll second that motion. Here.
We can call for a vote.
Board Member Knox?
Yes.
Board Member O'Hara?
Yes.
Board Member Osaki?
Yes.
Board Member Shanebeck?
Yes.
Chairman Walde?
Yes.
Board Member Busin?
Yes.
Vice Chair Drabala?
Yes.
Motion passes. The variance is approved, Mr. Chairman.
All right.
Now we get to
Now,
listen
if
to
you guys really want to stay for a treat, you can hang around, and we've got some.
Anybody with insomnia is,
If you'd like to, unless you want to sit for about
I'd say we got.
Each one takes about an hour.
thank you for
Thank you.
beautifying your property. That is nice out there.
All righty. So I'm going to.
You go back.
Yeah. Let's see.
The 20.
Yeah, okay, so, we're gonna move back to new business, 20-589, presentation discussion of conflicts of interest, open meeting law, public record law, parliamentary procedures and code of conduct by the city attorney. We're all waiting on pins and needles. I'll turn the time over to Mr. Stern.
Can I speak to Larry real quick?
Yeah.
This is all fun until we screw something up.
Yeah, I know.
It's true. We don't want to get together as a group.
Until you actually do it, you don't know what you're doing.
Oh, that's what I,
So don't worry.
that's what I read through, I'm still just,
Sorry, don't put on this tab, you should have seen what I got.
yeah, well, no, I remember what you got, yeah,
Was yours the same way the first time?
yeah.
I had about the easy case, but, well, the chairman was sick, the chairlady.
Oh.
It was Jane, I think Brown was her last name, but she was failing, and I forced her to be president, and she nailed me back as vice chair. So when she couldn't make the meetings anymore, I inherited the position, so to speak. And then we ran in that really messy one with the hitching post for my grand finale.
Oh, that was,
Yeah, that was no fun.
That was probably one of the biggest ones that they've ever had here.
I figured I paid my dues.
Okay, good evening.
Good
Good
evening.
evening.
And once again, to the board members who have been appointed, congratulations.
Thank you.
That meeting you just had, that's not the standard meeting, just to let you know. That was a pretty easy one. So there's been contentious ones before, and hopefully we never have those again, but I don't think that's the case, because that's why people come to the Board of Adjustment, usually because there's a disagreement with staff. That's usually what happens, but let's go positive. Let's talk about conflict of interest, open meeting law, parliamentary procedure, public records law, and the code of conduct. So, number one is the conflicts of interest law. I don't want to spend a lot of time. I was just joking. 3 hours is a long time. But you could spend a day on this stuff, really. You really could. You could have a whole conference all day long on these items.
I did at the state thing.
And that was about all day, wasn't it?
It was.
And that didn't cover everything, did it?
It was thorough, but actually, you do better with as much in a nutshell as they do with all day.
Well, thank you very much. I appreciate that.
I wouldn't say it if I didn't mean it.
So what is a conflict of interest? Well, what's the object and purpose? And I'm not going to read every word here, but basically it is to remove the limit or limit the possibility of personal influence which might bear upon a public official's decision. So the most common one is a substantial interest. So that means, is there a pecuniary or proprietary interest that you as a board member have on any item that you're voting on? And it's not just you, it's your relative too. And if you take a look at page 6, relative is defined. So not just you, but an individual within 2 degrees of kinship, including spouse, child, child's child, parent, grandparent, brother or sister, or whole or half-blood, and their spouses and their parent, brother, sister, or child of a spouse. The reason I spend a little time on that slowly is because some people don't understand that it's also that type of relative. So you have to think about that when you make a decision. Are you related to anybody who comes before this board? Are you going to get some kind of proprietary interest because you passed a decision of the director and you didn't agree with him and you went with the owner? If you did that and now you also own part of the property or you're listed, that's a conflict, a direct conflict. Same with the passing of variance. It's the same thing, because you will get some advantage in that decision by owning the property. There's other types of conflicts of interest, but I'm not going to go through those because those are much less common. Why should you care? That's on page 2. There's criminal and there's civil penalties that could happen. And I don't want to go into what happens on a Class 5 felony, but you can go to prison on it, basically, and pay a huge fine. On a felony, it's $150,000. However, there's a way around this for certain things, and those are called exceptions. Starting on page 3, the most common exception. I'm not going to go through all these, but the one that does come up more than any other one is whether you're in a class. So that's under J. So what does that mean? Class interest. If member of a trade, business, profession, or other class of persons consisting of at least 10 or more persons with which no greater interest than that of other class members. What does that mean? Example. A church comes to the city council and says, hey, we want a steeple. And the steeple's taller than what Rudy and Larry will allow under the code. We want a 50-foot steeple. And so what if a member of the council is a member of that church. So can that person vote on that item? Who says yes?
I say no.
Who says yes? Okay, the yeses are wrong. Actually, there's two ways to look at it. The yeses are right because that person, it's if that church has more than 10 people in it, that's your class. So if you're in a class of 10 or more, and this is a real life situation that happened back in 2000, was it, Rudy? 99?
Yeah.
Where there was a church that came forward that needed to have a steeple that was a certain height that was above what the zoning allowed. So Mr. Bazine is right if the class is less than 10. So that's situations that do come up, and that could be clubs too, not just a church.
My question?
Yes, sir.
I'm a salaried employee of a church. In that case, in the case you just mentioned, would a salaried employee have to exempt themselves?
I would say if you're going to benefit from that decision, then yes.
And you could
Financially.
extend that, yeah.
Some way you might. Now, if you say you're not getting a direct benefit, you could argue it. But there's another thing you got to look at. How does the public view this? Even if you don't have a conflict, you remember that church? What do you think the Facebook people are going to say? They're going to say, yes, there is a conflict. Most definitely. So what do you do? Well, if you want to vote on it, what you should do is call me. You tell me what the facts are. I will then create a written opinion for you to rely on. And then you can take that opinion. Say you give me all the facts. Say you gave me that fact of the salary. I'll write you an opinion saying, I don't believe you have a legal conflict. However, there may be an appearance of impropriety. And so it's up to you if you want to basically conflict off. So, or I'm going to write a letter saying, well, there's other issues. Here are the other facts you gave me. And because of that, I don't think you have a conflict. So it's that second letter that's very important to a lot of, in the past, council members and some commission members. So you take that brief that I gave you, or it's actually it'd be a legal opinion from me, and I will file it with the city clerk's office. So it's now a public record. And then you could vote on the item. Now, if I'm wrong, you're good. Nothing happens to you. I'm the one that would be not necessarily in trouble, but if I'm wrong, then you relied on it, so your vote is still good. So I wanted to bring that up. If a judge says, oh, Stern was wrong, I have to void the decision, a judge could do that. But nothing happens to you as a board member. Now, typically for a Board of Adjustment, it didn't happen tonight because I reviewed your file, I talked to planning staff, zoning planning staff, and I felt I didn't need to bring an attorney on board for that. Usually I do when it's a very contested matter, or there is another attorney on the side. Now, I kind of guessed at how you were going to vote. Maybe I shouldn't do that, but I felt to avoid the cost of an attorney and a stenographer, that I felt that I should do that. The conflict of interest would come up for me, would be representing you as a board. Right now, I'm giving you legal advice on this information, and I feel I can do that as city attorney. But on a contested matter, I would have a conflict of interest because I represent the city being staff in this case. So when there's an attorney present who's on the other side, I'm going to have an attorney who will probably sit right there, and any executive session items, and we'll get to executive sessions later on, would be discussed with you in a back room somewhere before the meeting, before the item comes up on the agenda. That's how that will happen, so that you have a full idea of legally what you can do in that case. So I wanted to mention that also. Any questions on conflicts? I simplified it, but I think those are the main points that you should know about. And once again, you could call me anytime to ask about any of this information, and I recommend that you do if you need assistance. Okay, next is on your list, open meeting law. So, open meeting law, what is that? It's the public policy that meetings of public bodies be conducted openly, and that notices and agendas be provided for such meetings which contain such information as reasonably necessary to inform the public of the matters to be discussed or decided. So, what this means is, you notice that tonight we have an agenda. And on the agenda, certain things are listed, and they're specific. It's supposed to be specific enough to allow the public to know what you're going to talk about or decide. So that's one element of the open meeting law. Why should you care? Same reasons. There's penalties that could happen. There's nullification of the action that you take. If you violate the open meeting law, if you want to discuss something that's not even on the agenda and you vote on it, that vote is probably, most likely, illegal. If it's not on the agenda, it's illegal. You have to have it noticed. When does it apply? It applies when there's a quorum. What is a quorum? That means at least 4 members of this body. And you're a public body under the statute. So 4 members are present, and you're talking about an item. What's supposed to happen is there's supposed to be a notice of that meeting, and there's supposed to be an agenda that goes with it. So if you go to a social event, I don't know, someone's getting married at the city and they invite all of you. Can you sit together? Well, technically you can, it's a social item, but the Attorney General would probably look at that differently if there was a complaint. Can you go to council meetings together and sit together and just start talking? Well, you probably can, but it's not recommended because someone's going to complain, especially if there's a case that's coming up that's going to be in front of the Board of Adjustment. And someone's going to complain and say, hey, they're talking about my case. Well, that person probably doesn't know that. They didn't hear you. But someone might make a complaint, and now the Attorney General's involved. And you don't want the Attorney General involved because they can do depositions, they could do public record requests and make life completely miserable. And that's what they're not supposed to make people miserable, but they're supposed to look at the rules, and they're supposed to investigate it, and they're supposed to come to a conclusion and stop any irregularities that are happening. So, as I stated, you're an advisory. Actually, you are a body, a public body, and you're quasi-judicial. What does that mean? That means you sit as judges, not necessarily legislators. So, what happens on the appeal? That's the key question. If somebody appeals your decision, where does it go? It doesn't go to the council. It does in other cities that have over 100,000 people, but not in this city. We don't have that population yet. So it goes to Superior Court. That's where someone has to file. And that makes it quasi-judicial, because your decision cannot be overturned by the city council. Not yet. Not that they would ever disagree with you. Notice. A notice of the meeting must take place. So, not the agenda necessarily, but the notice has to be posted in 3 different spots around the city. And we also post on the internet. The agenda is also placed on the internet so people know what's going on. I'm not going to get into emergency meetings. We don't really have those, especially with Board of Adjustment. We talked about the agendas. I will say that there was an issue about minutes in the past, and whether the minutes had to be verbatim. So tonight, your new some of you are new members, and you saw the minutes. And I'm glad you all voted because it's an administrative process. So you, as a board member in that position, can vote on it, even if you were not at the meeting. So I want to make that clear. And the minutes don't have to be verbatim. The city has to post this session right now, and the city will be doing that by putting it out there on video. That is enough under the law. So we don't have to have a stenographer here. We don't have to have someone that takes every word and writes it down and then puts it in some kind of memo. We don't have to do that. In the past, there has been for the council a person who did take really close notes. A deputy city clerk did it. And some members of the public were used to that because it was easy reference, a lot easier than going back online looking at the video of the meeting. But the law is it doesn't have to be verbatim as long as we post the meeting within 2 days, and we do that. Okay. Executive sessions, I already mentioned. Those are secret meetings. And secret's a nasty word in the world of open meeting law. However, statutorily, when you go in and meet with your attorney, you know, when there's going to be a case where we have an attorney, you can't tell anybody what happened in that meeting. Someone's supposed to take minutes. It can't be Rudy because he's going to be on the side of the city. It can't be Larry. So one of you will have to write down minutes, and those don't have to be verbatim. They can be general. And then you give them to your attorney, who then will give them to Rudy for sealing in the record.
Is that new?
No.
Well, we've never done that.
I'm sorry, I didn't hear that.
Okay.
Well, you're supposed to take minutes on all executive sessions.
First I ever heard of that.
Well, your attorney was supposed to tell you that.
Well, the attorney took notes, though, Joel. The outside attorney, when we did the case?
Yes, if he did that, that's fine too.
Yeah, he took his
Okay.
notes, yeah.
Okay.
And he gave them to us, yeah.
Well, then that's just as good. That's better because then you're focused on the issues, and you should be focused on the issues, especially when it comes to variances. Those can be very difficult cases depending on the circumstances. So once again, it's confidential. You can't tell anybody what happened at the executive session. There are some categorical exemptions, and I put that on page 6 for executive sessions. I think we could move on. Some of you are falling asleep already. Okay, public records law. Public records and other matters in the custody of any public officer shall be open to the public for any person at all times during business hours. The core purpose of the law is to allow public access to official records and other governmental information so that the public may monitor the performance of governmental officials and their employees. So, what does this mean? This means if you're taking notes right now and you decide, okay, I like these notes, I need them for whatever, say it was an item that you were adjudicating. What you're supposed to do, especially if you looked ahead of time at the case and you took notes, you're supposed to give those notes to the Development Services Department because that's a public record. You're supposed to keep that. And that includes not just handwritten. It also means anything you send, especially to each other. Hopefully you're not doing that, but if you do that, do not send it to, don't make it 4 of you, because then now you have an open meeting law violation under the open meeting law. But say you send an email to another member saying, hey, do you understand number 2 of Rudy's memo? And then you're going back and forth on it. Technically, that's a public record. And you're supposed to save that public record. You're supposed to give it to Rudy. That's what you're supposed to do. at the end of the item, after the item's been adjudicated. Yes, sir.
Wouldn't it be easier just to call Rudy?
Just to what?
To call Rudy if you have a question.
Oh, of course.
And
but
then that way,
sometimes-
if he's got to write it down, he can write it down, right?
Well, he doesn't have to write anything down unless, you want to write something down. If you want the answer, yes. But,
Well, if I get the answer verbally, I don't need to write it down.
Well,
Hopefully, my mind is still intact.
well, you're a veteran of this board as well as P and Z and the council, but new members may not understand or may want to have it so they can understand what's going on and then go back to it later if they decide to look at the case at a later date before the actual meeting occurs. So, but if you create a public record, you're supposed to keep it, and someone could do a request. In other words, if, say, the applicant didn't like your decision, and they want to see everything that was written on this, not just Rudy's notes or Larry's, they want to see yours, and there is something, and there's emails. Well, you are definitely supposed to keep that record, and that is completely disclosable to the person requesting it. They can get those records. So be careful what you put in emails. So why should you care? Well, for the city purposes, if the city, say someone does the public record request, and now the city has to come up with those records, and you're not being timely by getting that information to Rudy. The law says you have to do it promptly. Now, that's a hell of a term, promptly. What does that mean? Well, the courts have tried to define that. Under B on page 2, public entity must promptly furnish the public records request upon request. So that means quick to act or do what is required or without delay. So say it goes to the city clerk and then Rudy gets it, and I'm supposed to look at every public record that is considered a public record. So say Rudy is trying to compile it, and now we're out at week 8. Well, what could happen is, if they have an attorney, or even if they don't, they can come forward, file an action at the court and say, they didn't do it promptly, Your Honor. I want my attorney fees and costs. And the court will then, we'd have to come up with an affidavit as to why we didn't create that record for disclosure. And if the judge thinks we were not prompt, the city's going to be hit with a bill for attorney fees, the other side's attorney fees. So it's important that any records requests that come in, and you'll get an email from Rudy saying, hey, I need the records from this date to this date regarding this item. Please be prompt in getting that to Rudy. Now, there are some exceptions.
Joel, I'm sorry, just a quick question. So ideally, if a board member writes notes at a meeting, or they write notes on their staff report prior to a meeting, or there's an email exchange of some sort, ideally, that information should be given to staff after a meeting or within a day or two after the meeting.
After a decision on that item, yeah, because if there's a continuance, it could come later, but all the information really should go to Rudy.
It could be a copy, correct? Copy rather than original?
Well, if it's just an email, you can just copy it off, or you could send it to Rudy
I'm
electronically.
saying notes on our,
If your notes on it, a copy's fine. Yes. Now, we had a situation, 20 years ago, where there was this is an example, this doesn't affect you, but I'll give you an example of how we got burned. There was a settlement of a shooting in the city. The city contracts with what's called Southwest Risk. That is our insurance pool that we have with, I think, I don't know how many cities now, 70 or 80 cities. So they hired an attorney to handle the court action. And that attorney handled the shooting for us. There was a public record request for the settlement agreement. That attorney said, no, this is private. We're not going to let you know how much we settled on that. And then he went off to Europe. So, of course, the press came in. They wanted a copy of that settlement agreement. And finally, it went before a court, and the court said, this is not confidential. This is a legal document of a municipality. And city, you should have provided it. City meaning that attorney, the hired attorney. And so we got stung with a $26,000 attorney bill. Not doing that. So there was some time involved with a big law firm on the other side, but it was not good. Okay. Let's go to who can obtain a public record request. Pretty much anybody. And it could happen during litigation too. And you'd think litigation has its own schedule for documents. Well, it does, but someone could also do a public records request just to harass the city, and we do get those. So there's some states have a provision saying not litigation. You have to go by the litigation process under the civil rules of procedure, but not in Arizona. And so they can do a public record request anytime. There are some exceptions to the Public Records Act, and that's above that. It's under C, exceptions, statutory confidentiality exclusions, privacy interests, and best interests of the state. And there's a whole bunch of cases that talk about that at the end of this document. I'll let you read those on your own. We can charge a fee for the public record, which we do. There's been, if it's a commercial request, meaning they're going to get that document or documents, and then they're going to make money off of it. We can charge 50 cents per page instead of the 25 cents. And by the way, the press, when they make a public record request, that's not for commercial purpose, even though they're selling papers. It's First Amendment. That's what the courts have ruled. And then the rest are some really interesting cases. I think they're interesting. I put them in here. Hopefully you read this, and if you have any questions, please call me. So, okay, I think next, unless there's any questions, we can go to parliamentary procedure. So what did we do tonight? We picked a chair and a vice chair. How painful was that? Well, I'll tell you what, it could have been a lot more painful if you didn't have this cheat sheet in front of you, because that has happened in the past. Now, I drafted this with Rudy and Larry's help a number of years ago, and also Barbara Kelly, to give due credit. But a lot of this comes from what's called Robert's Rules. What is Robert's Rules? That's under paragraph 2 of the first page. It basically was a book that a military person created when he was assigned to go to a church meeting. And it didn't go so well at that meeting because there was no structure whatsoever. And Robert, Henry Martin Robert, decided, okay, I never want to go through that again. Let's have a rule book. And he created it. And we're like on the 11th edition now. But it's gone through the years, and it first applied to small groups, and at one point Congress actually adopted a version of it. So it's not real applicable to local entities, but there are some aspects of it that are. And it really goes to goals. What are the goals of your meetings? Decision-making is done by a majority vote. Every member of the voting body has equal rights and privileges to make motions, ask questions, speak, and vote. Minority views may be heard and considered. The process is simple and direct. There is a requirement to follow the basic motion rules. Generally, one question at a time is considered. Voting members are to be impartial and should seek recognition from the chairperson before speaking. Should never make or engage in personal attacks with other members, staff, or the public. A lot of common sense stuff here, but some people don't have common sense. And I'm not saying any of you don't have common sense, but some people don't, and it's good to have rules. And so we go by Robert's Rules. It's not a law. The book is not a law book. So if we violate Robert's Rules, it's not really going to affect the decision. Unless it's an open meeting law violation, then it would, or a conflict of interest issue. So motions are pretty easy to make, and I've kind of outlined the types of motions. I move to amend the motion by blank. I move to table the motion and continue on and on. So they're pretty easy to do. Now, during contentious hearings, it is really important for the chair to make sure that whoever wants to speak is recognized. Otherwise, you start talking over each other, and it becomes a nightmare very, very quickly. Especially if there's counsel from the other side, and there will also be a stenographer here. The reason I have a stenographer, I don't have to do that, because this is being taped, videotaped. However, if the tape recording goes, the one that Larry controls over there, and the video goes, how is someone going to appeal that decision? Well, they'll file a notice of appeal with the court, and the court's going to say, where's the record? Well, sorry, Your Honor, the tape recorder died. It was 110 that night, and I left it in my car, and also the video didn't play. We had a bug in our system. We have no record. All we have is the decision, and here's the chairman signed the decision. So what's the judge going to do with that? Judge is going to say, okay, new trial.
Start over.
Let's have a new trial. And who wants to go through another trial that this board has already done and decided? Now you leave it up to the judge to decide all the issues. What a judge is supposed to do on appeal is to review what the board did and whether it was an arbitrary or capricious decision, meaning there was no basis to it. That's what a judge is supposed to do in a Board of Adjustment appeal. So I bring that up because that does have something to do with parliamentary procedure. You want to keep to the rules, and you want to make sure everything's orderly, especially when a judge looks at a transcript or watches the video, and the judge wants to make sure everybody got a chance. Because if a judge sees that there's all sorts of odd things going on at this level, then a judge is going to insert his or her own opinion about what the issues, how they should have been decided. I've seen that before. So you did nomination of officers. Well done. We had a few quirks, but you know what? You did a good job. Wouldn't you say they did a good job?
Absolutely.
Absolutely. I think so too. So the one on the green sheet on page 3 is essentially a summary of what Rudy had handed out. Okay. Any questions on that one? No? Okay. It's almost 8 o'clock. We're almost out of here. Council, Board, and Commission's Code of Conduct. Let me first say that this document, although I wrote several renditions of it, this used to be 12 pages long. So what the council adopted was 4 pages long. The council had changed a lot of things that were originally in it. I took it from different cities and towns. However, for this city, this is what the council felt was appropriate by the current, actually 2018, I think, is when this was passed. So by that council. So some of this is overlap with some other material here. But what do? Act in the public interest. That is the point of conduct. That's the common goal, equal treatment. And it goes into potential conflict of interest or perceived. Once again, we kind of talked about that already. Comply with the law. That is real important for this board. There's going to be cases, and there have been cases, where, in my opinion, were voted on just based on sympathy for the applicant. And the law wasn't even considered. I believe that happened in the 23 years that I've been here. I've seen it. And you're supposed to follow the law. You may disagree with the interpretation of the law, but you're supposed to follow the law. So going to professional conduct, this is common sense too. Members shall conduct themselves above reproach, and shall avoid even the appearance of impropriety. Once again, going back to conflict of interest. They should never act in a matter where their impartiality might be reasonably questioned. They have a personal bias or prejudice concerning a party or representative thereof, a staff member or members of the public who support or oppose the party. They have personal knowledge of facts that are in dispute that would not be known by staff or the public at large. The question is whether impartiality might be questioned from the perspective of a reasonable person. I took a lot of this from actually the state bar oath of attorneys. That's where a lot of this comes from. And the council accepted it, so it's applicable to themselves and boards and commission members. Public meetings and due process. I'm not going to go through all these, but this is really common sense stuff. And we've already talked about some of these items: due process, seek recognition from the chair, be fair, objective. Advocacy. Members do not lose their First Amendment rights by virtue of becoming a member. However, when they decide to engage in social media, LTE is letters to the editor, which is less and less common because we don't have any paper. We have very few papers now. Articles or other public statements, they must not hold themselves out as being associated with the city, and they shall explicitly advise that their views do not necessarily reflect the views of the city or the majority of the public body. So what does that mean? So you decide an issue, and you're done. And you feel pretty good because you felt the applicant got what they really requested and deserved. Do you then go on social media to say how wonderful you were because you voted for that? I wouldn't recommend that. I've seen that done. There's something that feels wrong about it. But especially afterwards, what could be used is if that social media message is, say the applicant didn't get what they wanted. And so now you got some member out there saying, yeah, I voted that way because I think that person was a jerk. Or I talked to 3 other members and they didn't think it was a good idea. So now social media, it's everywhere. It's on Facebook. If the applicant finds that out and they didn't get their way on an item and they appeal it, well, that's going to, and they bring that as one of their causes of action, that there was some kind of open meeting law violation. That's an issue that has to be dealt with by a judge. And you could then get a subpoena. So that means you might have to go to court to testify what you were talking about when you sent that social media message. Trying to get you out of a subpoena is difficult, although you are quasi-judicial. You have a legislative capacity, you would have immunity, you still might have to testify. So be careful what you put on social media. I wouldn't put anything on if I were you, especially on cases that you are deciding before, while on this board. Also, members shall refrain from attempting to influence other member positions unless such communications and discussions are heard in public at a regularly scheduled public meeting. That means don't be talking to other members about this. You should never do that, in my opinion. If you have a question, talk to staff, but don't talk to each other about this. Don't email each other about it. Hey, Thursday night or Monday night, we're going to have this meeting. How are you going to vote? Oh, that'd be good. Don't do that. And certainly don't say, hey, I'm going for the applicant. I hope you do too. Or I have 2 other members. One more, and then we'll have the applicant get their variance. Don't do that.
Hey, Joel, that
Yes.
includes talking to the applicant as well in these types of cases. I think a planning commission is a little bit different, but
Sure.
in these cases, I think driving by the site is fine, but like going onto the property, measuring how far it is from a back of a wash, because then the applicants might come out of the house, and then now you do have information that others might not happen, but then you're also talking to the applicant. I think in this board, all the information should be gathered really through staff or from the, during the public hearing or the applicant's presentation. Is that fair to say?
I think it's very fair to say you should not be talking to the applicant. And if they contact you, do not respond back. And it's not because you're being difficult, it's because of what Larry just said. you're going to create a situation where you're now talking to them, and they're going to give you additional information that all of you don't have, at least in that moment. And then you might be talking to other members, which you shouldn't be doing, but if you do, now basically it's contagious and it goes to all of you. And then the applicant might get up and say something completely different. So any information is usually done through staff. And then the applicant has the ability to submit to staff any kind of position on it and any attachments. They will give that. And Rudy and Larry are very good at that. They will give that stuff to you electronically. And if you want it, I think they'll even print it out for you. I think you're still doing that service, correct? If you want it. Okay. Non-interference with and treatment of staff. Be courteous to staff. We've had situations where we've had board members not being so courteous to staff for different reasons, but be courteous to staff. They're just doing their job. They're just effectuating their interpretation, or they're effectuating the facts of the case. That's all they're doing. Staff does not have bias against any member of the public or any applicant or any homeowner, and never did. From all my time in this city, I've never seen that from any planning staff member. Never have seen that. There have been allegations that that's happened, but it has not happened in my opinion. Gifts, I'm going to skip that. That doesn't really apply. Meeting distractions. This came up with the use of cell phones and social media also. Social media is not the 8th member of this board. Don't make them the 8th meeting or 8th member. In other words, if someone during the meeting, public hearing, and right now the policy is if someone sends you something from Facebook, that is not a person who you shouldn't be repeating. I'd say, hey, so-and-so says this, I want to ask that question. That's not the law here. It's not the policy of the council to accept that. It may be in the next few years or less, but that is not the policy right now. If someone writes you from Facebook, first of all, you shouldn't be looking at your phones during that time period, in my opinion. But some people disagree with me, and they think Facebook should have some kind of impact on your decision. So say you are talking to someone on Facebook during the public hearing. Rather than identify that person, you ask the question. So make it your question. That's what I would recommend, if at all. But do what you want to do, but that is my recommendation. We already talked about communication with litigants. Attendance at meetings. If you can't be at a meeting, please contact Rudy, because after 3 unexplained absences, technically you can be thrown off the board by the council, and we don't ever want that to happen. And let's see, incompatibility of office. If you remember doing the appointments, there was discussion on whether you could be on this board and serve on the planning and zoning board. That's a direct incompatible situation. As a planning and zoning member, you're passing legislation, or you're recommending the passage of. In conditional use permits, you're actually making the decision, subject to an appeal by council. That's incompatible with this directive of this board. And so that's why you cannot be on planning and zoning as well as this board. And once again, you're in a quasi-judicial situation. Other boards, that's different, because you're not deciding zoning matters, planning and zoning matters. There is a legal training requirement, and I think Larry you're going to send out an invitation to do that. Also, this counts as training also. So I'm glad you're all here tonight. And staff recommendations. Don't take them lightly. Those 2 individuals are, between the 2 of them, let's see, 30 plus 70 years experience, right? Something like that?
Not quite that.
Oh, I don't know. They have a lot of experience in planning zoning matters. You may disagree with their interpretation, but keep in mind they have a lot of experience and they've seen a lot of cases. And if you don't understand something, please ask them during the hearing. Very important that you do that. I think that's it. Any questions on any of this information?
Just a statement to the new members of the board who haven't dealt with the city staff and attorney. They are really easy to contact and talk to. No reason to hesitate whatsoever.
Thank you.
Yeah, it's true.
Yes.
The only question I have is, you're saying that we shouldn't even go and visit the property and look at it?
No,
No, I said you could do that.
you can
We
do
could
that.
Yeah.
But I
Don't
understand-
drive onto the property and start engaging with the.
No, I
yeah.
understand that part. All I'm doing is.
But driving by and looking from the street, that's, or an aerial photo on Google Earth, certainly that's okay.
Okay.
Yeah,
Well,
yeah.
one thing
Sorry
I
about that.
do want to mention, we did have a board, that was on P&Z, but I'm going to say it anyway. That member, he took his role extremely serious, because I think the state he came from, the Planning and Zoning Commission had a lot more power. So what he did was he went and purchased some magnets, big magnets that got put on his door. Planning and Zoning Commissioner, and then his name. And then he took his truck out to the locations, and so it looked like an official city vehicle. And people would then come out of their house and then talk about whatever case that he was investigating. Please don't do that. The city's not going to issue a magnet. I am very sorry. I just violated the rule
Here, let
of
me go back
conduct.
to that rule. What's that rule again? Code of conduct, let me
Yeah,
see
no.
which one I violated.
I'm not even going to, okay, I apologize. That's supposed to be turned off. So yeah, you're supposed to turn your phone off, so. Any other questions? Mr. O'Hara, did you raise your hand? Oh, okay, okay.
Any other questions? All right, thank you.
Well, thank you very much for the time, and once again, call me if there's any questions whatsoever.
All right.
Thank you.
Okay, seeing as we had no old business, we're going to move to Section 8, 20-584, regular meeting at 7 p.m. on Monday, December 14th, 2020, in the City Council Chambers located at 300 East Superstition Boulevard, Apache Junction. And then I call, and then I adjourn the meeting at 8:12.
Nope, you have
Oh, wait.
to,
I got to do one more thing.
Motion.
you need a motion to have the next meeting December 14th.
Oh.
Now, we probably don't have a case, but we always set the meeting up and then we'll send a cancellation.
I'll
Okay.
make a motion that we have the meeting on December the 14th at 7 p.m. on Monday in the City Council Chambers located at 300 East Superstition Boulevard here in Apache Junction.
Can I get a second?
Second.
Alrighty. Rudy?
Board Member Busin.
Yes.
Board Member DeBrala.
Yes.
Board Member Knox.
Yes.
Board Member O'Hara.
Yes.
Board Member Osaki.
Yes.
Board Member Shanebeck.
Yes.
And Chairman Walde.
Yes.
So, did I skip somebody?
Nope.
No, I think we got a unanimous decision, Mr. Chairman.
Alrighty.
Now you can.
Okay, now we're going to adjourn at 8:13.